From The Australian, here's what's on the front. I'm Claire Harvey. It's Wednesday, June 25, 2025. Did Erin Patterson lie to police or lie to the jury about foraging and dehydrating mushrooms? That's one of the big questions posed by the mushroom trial judge to the jury as he prepares them to deliberate over a verdict on Patterson's triple murder charge. Today, we dig into the judge's detailed instructions. Don't let your sympathy cloud your judgment. That was the core of Victorian Supreme Court Judge Christopher Beale's summing up. The courts call it a charge to the jury in the Erin Patterson triple murder trial. Patterson's pleaded not guilty to murdering her husband's parents, Don and Gail Patterson, and his auntie, Heather Wilkinson. She's also pleaded not guilty to attempting to murder his uncle, Ian Wilkinson, with beef Wellington that included death cap mushrooms. Patterson says it was all a terrible accident.
It's for you and you alone to decide whether she is guilty or not guilty of these offences.
That's a voice actor reading the words spoken in court on Tuesday by Justice Christopher Beale.
The verdict you return has absolutely nothing to do with me. You alone are the judges of the facts in this case.
But Justice Beale's role is to direct the jury on points of law and to help the jury navigate their way through 8 weeks of evidence. Right now, there are 14 jurors sitting in the trial. When the judge finishes his charge later this week, the jury will hold a ballot to shrink their numbers to 12. And those 12 must come up with a unanimous verdict on every charge, guilty or not guilty.
You must ignore all other considerations, such as any feelings of prejudice or sympathy you may have for anyone involved in the case. You should not, for example, be influenced by the mere fact that Erin Patterson cooked the fatal meal. The issue is not whether she is, in some sense, responsible for the tragic consequences of the lunch, but whether the prosecution has proved beyond a reasonable doubt that she is criminally responsible for those consequences. Similarly, the fact that, on her own admission, Erin Patterson told lies and disposed of evidence must not cause you to be prejudiced against her. This is a court of law, not a court of morals. Nor must you let sympathy for the extended Patterson or Wilkinson families cloud your judgment. Don't misunderstand me. I'm not asking you to be inhuman. None of us are robots. Any decent person would feel great sympathy for the Patterson and Wilkinson families, given what has befallen them. But you must scrupulously guard against that sympathy interfering with the performance of your duty. Remember, you are judges of the facts. That means that, in relation to all of the issues in this case, you must act like judges, or at least good judges. You must dispassionately weigh the evidence logically and with an open mind, not according to your feelings.
The judge also said jurors must ignore anything they'd heard or read about the case, whether in the media or on the street. Here's what he said about Erin Patterson, the accused, who spent days in the witness box.
In this case, Erin Patterson chose to give evidence. She did not have to do that. As an accused person, she has the right to remain silent in court. As I've told you, it is the prosecution who must prove Erin Patterson's guilt beyond reasonable doubt. It is not for her to prove her innocence, and this has not changed because she chose to give evidence. In choosing to give evidence, she undertook to tell the truth. She also submitted herself to cross-examination, which is the way lawyers test a witness's credibility and reliability. There are 4 broad conclusions you must reach about Ms. Patterson's evidence. First, if you think it's true, then you must find her not guilty of all 4 charges. Second, if you are not sure whether her evidence is true, but think it might be, then you will have a reasonable doubt about the prosecution's case. And again, you must find her not guilty of all 4 charges. Third, it's not enough that you prefer the prosecution case to Ms. Patterson's evidence. It's not sufficient for you to find the prosecution to be preferable to the defence case. It's not a question of simply balancing one case against the other or choosing which one you prefer. Finally, if you do not believe Ms. Patterson, that does not mean that you must find her guilty. Instead, if you reject her evidence, put it aside and ask whether the prosecution has proved her guilt beyond reasonable doubt on the basis of the evidence that you do accept.
The judge said it was a critical part of our justice system that Patterson is presumed innocent.
You have evidence from a number of witnesses that she has no criminal history, who over many years has been a devoted mother, a loving daughter-in-law, and a generous and caring sister-in-law.
The judge said if the jury accepts Patterson is a person of good character, they might consider her more trustworthy than a person who was not of good character.
Of course, this does not mean you must find her not guilty if you accept that she is a person with good character. The mere fact that a person is of good character cannot alter proven facts. It can only help you to determine whether or not those facts have been proved. In addition, you should keep in mind the fact that a person who has previously been of good character can commit a crime for the first time.
On to the facts. The judge gave jurors a summary of what each witness had told them. But first he reminded them of some of the controversial moments of the trial, and he gave them the example of a moment Erin Patterson described in the days after the fatal lunch when she was a patient at Monash Medical Centre in Melbourne.
You will recall that Erin Patterson alleges that at one point in the course of the conversation, the children left the room momentarily. She alleges that Simon said to her, quote, "Is that how you poisoned my parents, using the dehydrator?" And she told you that she answered, "Of course not." You'll recall Simon Patterson's evidence when that was put to him in cross-examination. He said, "I did not say that to her."
The judge reminded the jury that defence lawyer Colin Mandy SC said that moment was the fulcrum, the turning point, after which Erin Patterson says she became worried about Simon's conduct and changed her mobile phone so he couldn't contact her. The judge said that was an example of the kind of controversy he didn't include in his chronology of the case provided to the jury, because he said it was up to them to decide who was telling the truth. Coming up, how the jury is to sift through Erin Patterson's time in the witness box. The judge took the jury to something called tendency evidence. That's about whether or not she was in the habit of foraging for mushrooms. Patterson told the police when they interviewed her just days after the lunch that she'd never foraged for mushrooms and had never dehydrated food. But at trial, she told the jury this was something she'd been doing since COVID lockdown, when she and the kids would go on walks to the local botanic garden and rail trail. She said she'd pick non-toxic mushrooms and dehydrate them because the mushroom season was short and she wanted to be able to eat them all year round. Here's what the judge said, summing up the defence case about Patterson and her evidence.
The defence makes the following arguments. She loved mushrooms, not only according to what she said in evidence, but according to her Facebook friends. The fact the kids don't remember her foraging for mushrooms is consistent with them just being young kids. It wasn't something she did every day. She didn't hide the fact that she'd purchased a dehydrator, instead broadcasting that fact to her Facebook friends, which she wouldn't have done if she was deliberately planning to dehydrate death cap mushrooms to poison her in-laws. She would have not only concealed the fact of the dehydrator, she would have got rid of it once she deliberately dehydrated the death cap mushrooms. It's argued that she gave a consistent account in her testimony and came through cross-examination unscathed.
Then the judge summed up the Crown case.
The prosecution made the following arguments. The only evidence that she foraged for edible mushrooms came out of her mouth. She's a self-confessed liar. There were no messages to Simon or the Pattersons group regarding foraging for edible mushrooms, no messages to the Facebook friends regarding foraging for edible mushrooms, no books on foraging edible mushrooms found during the searches of her home. She denied being a forager of wild mushrooms. It was argued that claims to have been a forager for edible wild mushrooms is a recent invention because of a realisation on her part the story about the Asian grocery mushrooms didn't add up.
And this is how the judge said the jury could use that evidence about whether or not Patterson had a habit of picking and eating wild mushrooms.
Having gone through the evidence and the arguments, you must take this evidence into account when deciding whether the prosecution has proved beyond reasonable doubt that the accused deliberately put death-cap mushrooms in the beef Wellingtons. If you find that she had a tendency to pick and eat wild mushrooms, including putting them in meals she served to others, or if you think there is a reasonable possibility that she had that tendency, you may consider that it increases the possibilities that the death-cap mushrooms ended up in the beef Wellingtons accidentally rather than deliberately.
So, if Patterson is telling the truth about foraging now, the judge says the jury might believe her claim it was all a terrible accident. Justice Christopher Beale will continue his summing up on Wednesday. The Australian's covering every moment of this trial, and our subscribers will be the first to know when there's a verdict. To join us, go to theaustralian.com.au.